And so Trump got blocked on that one, too. Shall I keep going? I could keep going. Another federal court just blocked Trump from freezing billions of dollars for childcare and social services for kids, again, in Democratic-run states, as some kind of punishment against those states for electing Democrats, punishing them for that by cutting off the Temporary Assistance to Needy Families program. Because, what would Jesus do? Trump was also just blocked from doing that by yet another federal court. It's almost like he is losing all the time and everywhere now. There may still be people in America who are shocked that Trump keeps breaking the law over and over again, blatantly and insistently. The courts no longer appear to be shocked by that. And the courts now are just telling him no, very bluntly, every single day and often multiple times a day.
Tonight, the consequence lands before the background. Federal courts are boxing in the Trump administration in real time, and they are doing it with the blunt instrument of injunctions. Billions in clean energy funding, money Congress already appropriated for projects across the country, gets targeted for cancellation on a partisan map. The administration does not hide the split. Keep the funding in states that voted for Trump. Cut it in states that did not. A federal judge reads the admissions, reads the appropriations, and blocks the move as illegal. The money stays where Congress put it because the presidency is not a veto pen after the fact and not a private bank for punishment. Imagine governors opening spreadsheets and seeing a court order that keeps the checks alive. Picture projects snapping back online because a judge said no. Now watch the second hit in the same news cycle because this is not one lawsuit, it is a pattern. The administration tries to shut down an offshore wind project tied to Rhode Island and Connecticut. A wind farm is not a talking point. It is contracts, permits, crews, timelines, lenders, and public commitments already priced into local economies. It is a visible build that carries visible politics, which is exactly why it gets targeted. The administration swings at it anyway, and the court swings back harder. Illegal. Blocked. Work continues. Picture the vessels returning to the water. Picture the crews clocking back in. Picture the local officials who staked their credibility on this project watching the shutdown order collapse in court. Then, the retaliation moves from states to institutions, from governors to doctors, from budgets to intimidation. The American Academy of Pediatrics criticizes the direction of federal health policy under RFK Jr., and the administration responds the way it keeps responding. It reaches for the lever it thinks always works, the lever of federal grants. Cancel the funding, punish the critic, make the warning travel. A judge reads the sequence and calls it what it is on the record: illegal retaliation. The grants must be reinstated. The government does not get to weaponize appropriated dollars to silence criticism, not in a system built on enforceable limits. Now, bring the stakes into the constitutional frame. The administration moves to cut off federal election funds to states in retaliation for refusing to change election rules the way the president wants. The court blocks it and states the core truth without apology. The Constitution assigns no authority to the president over federal election administration. No authority means no leverage. No leverage means the threat is theater. States keep their funds. The intimidation tactic collapses on impact, and the administration loses another tool it thought it owned. And then the child care and social services money, billions tied to kids and families, targeted again because Democratic-run states are treated like enemies. Temporary assistance and child care programs are not ideology. They are line items that keep people alive, keep kids safe, keep families functioning. The administration tries to freeze that money anyway, as punishment, as pressure, as a performance of dominance. Another federal court blocks it. The attempted chokehold fails. The money flows as Congress ordered. The programs stay open. The cruelty loses its mechanism. Here is the shock that matters. This is not one judge. This is not one jurisdiction. This is not one lucky ruling. It is the density of the word no. Every day, multiple times a day, courts from different benches converge on the same conclusion. The administration is breaking the law openly and insistently, and the courts are done acting surprised. They are writing like they understand what they are facing. They are writing like they intend to end the routine. That shift in posture is the pivot point, and it forces the next move. A a trust reset, and then a hard look at the legal machinery that keeps slamming the door shut repeatedly, publicly. Reset the trust. Briefly, because the noise is thick and the grift economy lives inside that noise. This is not a debate about whether clean energy is good. This is not a culture war skirmish about windmills on the horizon. This is the federal government trying to route money as reward and punishment, and the courts treating that move as a legal violation, not as politics. Watch the framing shift. The administration wants every loss to sound like a partisan fight. The judges write like accountants and constitutional officers. They are not scoring ideology. They are policing authority. That is the reset. The rest is mechanics. Mechanics first. Congress appropriates money. Congress writes the terms. Congress tells agencies what programs exist and what purposes the money serves. When the White House decides, after the vote, after the signature, after the appropriation, that it will keep the funds in friendly states and cut them in unfriendly states, it is not reprioritizing. It is substituting the president's political map for Congress's lawful map. Courts do not need to decode that. They read it, they compare it to the statute, and they call it what it is, an illegal attempt to reprogram appropriated funds. When an administration says out loud that the cut is tied to how people voted, it hands the court a straight line from motive to action to illegality. The constitutional fact remains, the purse belongs to Congress. Then, the wind farm piece, because it illustrates the same leverage instinct in physical form. A project with permits and approvals becomes a target because it can be made to suffer quickly. The administration moves to shut it down, and the court asks the only question that matters in federal court. Where is the authority? Not where is the outrage. Not where is the press cycle. Where is the authority? If the answer is executive preference, the case is over. Judges block action that lacks a legal footing, especially when it threatens immediate financial harm and contractual chaos. The order reads like a stop sign. Halt the shutdown. Restore the status quo. Let lawful work proceed. Uncertainty is harm. Courts know it. Now the retaliation doctrine, and this is where the record becomes poison. The American Academy of Pediatrics criticizes federal health policy. The administration cancels grants. A judge looks at timing, statements, and the internal rationale and treats it as punishment for speech. That is not a close call in the way the administration wants it to be. Retaliation does not become legal because the target is famous. Retaliation does not become legal because the president is angry. Courts protect the boundary because the alternative is a government that buys silence with public dollars and punishes dissent by starving institutions. The election funds ruling is the cleanest knife. The judge writes that the Constitution assigns no authority to the president over federal election administration. That line does not need decoration. It means the president cannot invent a supervisory role and then threaten states financially to force compliance. It means executive pressure campaigns cannot be laundered through grant mechanisms. It means the administration's leverage collapses because it was never real leverage. It was intimidation dressed as policy. And the standard for these blocks is not mysterious. Courts look at the likelihood of success on the merits, the irreparable harm, the balance of equities, and the public interest. Here, the harm is concrete. Billions withheld, projects halted, services disrupted, speech chilled, elections threatened. The equities tilt hard because the government cannot claim harm from being told to follow the law. The public interest is the stability of programs and the integrity of constitutional boundaries. When the executive loses on the merits this early, appeals turn into triage, not strategy. That is why the orders come fast. That is why the tone is blunt. And that sets up the escalation, because an administration that keeps pulling the same illegal lever keeps getting the same judicial response. This is escalation. And it is not rhetorical escalation. It is a procedural escalation. It is institutional escalation. It is the judiciary moving from surprise to pattern recognition, from isolated disputes to a running diagnosis of behavior. Picture the federal docket like a conveyor belt. Motion filed, record assembled, hearing scheduled, order issued, then another, then another. The administration walks into court with the same playbook and leaves with the same word stamped across it. No. Start with the clean energy funding case because it exposes the premise. The administration does not say, quietly, that it is doing a technical review. It says it is cutting funds in blue states, keeping funds in red states. That is not merely controversial. It is legible. It is a motive made audible. Courts do not have to infer. They read the statement, match it to Congress's appropriation, and write the remedy. Funding restored, discrimination blocked. The legal system treats it like what it is, an attempt to use federal spending as a partisan whip. Then, the wind farm case, and watch how judges respond when the harm is immediate and the rationale is thin. You do not shut down a major project and call it normal management. You do not yank a permit and call it a policy preference. The court looks for authority, looks for lawful process, looks for a record that survives scrutiny. When it is not there, the order arrives with the sharpness you hear in the wording. Stop the shutdown. Let the work proceed. Do it now. Every day that passes is money burned, contracts breached, and uncertainty multiplied. Courts understand the financial clock, and they treat delay as damage. Now, stack the retaliation case, because this is where the administration keeps stepping on the same rake. The American Academy of Pediatrics criticizes the administration's health posture under RFK Jr. Grants get canceled. A judge calls it illegal retaliation and orders the money reinstated. That is not symbolic. That is a court telling the administration that it is creating its own evidentiary record of motive. You cannot build a paper trail of punishment and then ask for deference. You cannot punish critics with federal funds and then pretend the Constitution is silent. The judge writes the boundary and forces the administration back behind it. Then the election funds case. The judge's line lands like a gavel. The Constitution assigns no authority to the president over federal election administration. That is not a technicality. That is a wall. That is the judiciary saying, in plain language, that the presidency does not sit above state election systems as a supervisor. The threat to pull funds is not policy, it is coercion. And coercion without authority becomes illegal the second it is tested. And then the child care and social services freeze. The attempt to squeeze programs for kids as punishment against Democratic-run states. Another court blocks it. Another order forces the funds to move. Another attempt at pressure turns into another written record of overreach. Keep going. The list keeps going. The administration's lawyers keep showing up with variations of the same argument, and judges keep answering with variations of the same refusal. The courts are no longer reacting to a surprise. They are reacting to a pattern, and patterns justify speed. This is why the tone is changing. Judges are writing like they understand they are dealing with a repeat actor who treats the law as optional and the budget as a weapon. They are writing like they intend to stop the damage before it spreads. That is escalation. Injunctions that arrive faster, orders that read sharper, patience that runs thinner. And when the courts reach that stage, the administration's public image starts to crack because Ian Mage cannot survive a daily schedule of legal rejection. Every press release sounds like defiance, but every court order reads correction. The gap between the strongman pose and the written record widens, and the widening becomes humiliation. Here is where the image collapses, because the administration has always sold an image first. The image is a command. The image is dominant. The image is the idea that a single will can bend agencies, bend budgets, bend states, bend the culture, and bend reality. But reality shows up in federal court as paper, motions, records, statutes, orders. And paper does not care about bravado. Paper cares about authority. So the image of control runs straight into the reality of injunctions, and the collision is visible. Every time the White House announces a cut, a freeze, a shutdown, a punishment, the courts answer with a receipt. Illegal. That receipt is what humiliates power. Not the insult, not the tweet. The receipt, the written order that says, you cannot do this. The written order that forces money to move, forces projects to resume, forces grants to be restored. And because these are not abstract fights, the humiliation is practical. Crews go back to work on that wind farm because a judge said the shutdown was illegal. States keep clean energy funding because a judge blocked the partisan cut. Pediatricians keep grants because a judge called the cancellation retaliation. States keep election funds because a judge wrote that the president has no authority here. The narrative of omnipotence breaks when the machinery keeps turning without you. Now, the options, because once the image cracks, every available move is bad. Option 1 is compliance. Obey the orders, restore the funding, stop the shutdowns, stop the retaliatory cuts. That is the lawful move, but it is also an admission. The administration acted outside the law and got stopped. Compliance looks like retreat, and this administration hates retreat more than it hates losing money, because retreat breaks the brand. Option 2 is appeal. Appeal to everything. Ask for stays. Try to slow the bleeding. But appeals do not erase the record. They preserve it. Appeals do not fix the lack of authority. They spotlight it. And appeals take time, while the injunctions operate now. So the administration ends up in the posture of a serial appellant, moving case to case, begging for pauses, and watching judges ask the same question: where is the authority? If the authority is not there at the trial level, it does not magically appear at the appellate level. The best an appeal can buy is delay, and delay is not victory. Option 3 is defiance. Pretend the order is optional. Slow walk compliance. Dare the courts. But defiance triggers the most dangerous chain: contempt, enforcement, escalating judicial remedies, and a constitutional crisis that is no longer theoretical. When a court says restore the grants, restore the funds, stop the shutdown, and the executive refuses, the judge does not shrug. The judge escalates. The judge compels. The judge protects the court's own authority because the entire system depends on it. Defiance is the path where the administration converts political theater into a legal emergency, and that emergency is unwinnable. Option 4 is substitution. If you cannot punish states through one funding stream, you hunt for another. If you cannot choke one program, you choke another. If you cannot silence one critic, you target another. But substitution is exactly what the courts are starting to recognize as a pattern. The more the administration substitutes, the more the courts write as if they are dealing with a repeat offender. Pattern recognition kills plausible deniability, and once deniability dies, the next orders get faster, broader, and less patient. That is the collapse. The administration is trapped between legality and brand. Legality requires restraint. The brand requires domination. So every move either abandons the brand or violates the law. That is why the losses feel constant. That is why the orders land like a drumbeat. And it forces the next frame, the one that matters more than Trump or any presidency. What happens when the rule of law meets a government that tests whether the law is real? This is the rule of law moment the administration keeps trying to outrun, and it keeps finding the same wall. Appropriations are not a mood. Statutes are not suggestions. The presidency is not a roaming veto that can reach backward and unfund what Congress already funded, not because a governor offended you, not because a state voted the wrong way, not because an institution criticized your health agenda, not because an election system refused to bend. Courts keep returning to the same baseline. Congress wrote the checks, Congress set the terms, and the executive has to execute, not rewrite. That is why judges are blocking the blue state energy cuts, blocking the wind farm shutdown, blocking the pediatric grants retaliation, blocking the election fund coercion, and blocking the social services freeze. Different cases, same defect. No authority, no lawful process, no permission in the text. Now widen the lens to the institutional fallout, because this is where the story stops being courtroom spectacle and becomes a governing crisis with a price tag. Every block forces agencies to reverse course, reopen programs, reissue guidance, and explain to career staff why yesterday's directive is today's legal exposure. That churn burns real dollars. Contracts get paused and restarted, supply chains get rerouted, deadlines slip, and risk premiums rise. Governors do not build budgets on presidential rage. They build budgets on enforceable commitments. When the White House tries to weaponize funding and courts keep snapping it back into place, the market reads the message clearly. The United States is still governed by rules, but the executive is behaving like a repeat offender. That is how you end up with higher costs for projects, slower rollouts, and a constant tax of uncertainty paid by everyone except the people who ordered the chaos. And while the judiciary is tightening the legal vice, Congress is showing movement that terrifies any White House built on party discipline. A war powers resolution advancing to block further military adventurism in Venezuela, with 5 Republican senators crossing to side with Democrats, is not a footnote. It is a flare. 17 House Republicans defying the administration on the Affordable Care Act after the so-called Big Beautiful Bill drove premiums through the roof is not a messaging problem. It is a survival reflex. Then comes the science rebuke, the quiet but devastating one. Trump demands steep cuts to the National Science Foundation, to NOAA, to basic research that has powered American innovation for decades, and Congress moves to undo them. In the House, Republicans are down to a margin so slim they can barely lose a vote when every Democrat shows up, and they already see the midterms coming like a truck. Add the political horizon in Alaska, with Democrat Mary Peltola announcing a run against Republican Senator Dan Sullivan, and the map stops looking like a locked wall and starts looking like a door cracking open. Courts closing lanes, Congress cutting loose. The institutional center of gravity shifts away from one man's impulse and back toward the system. So the options close, and they close in a way that leaves no dignified exit. Compliance means admitting the boundary and watching the strongman brand bleed. Appeals mean admitting the losses and begging for delay while injunctions operate now. Defiance means contempt, enforcement, and a collision the presidency cannot win without detonating the system it claims to lead. Substitution means pattern, and pattern means the next injunction arrives faster, broader, and sharper, because judges stop treating each episode as isolated and start treating it as serial conduct. Picture the final frame the way it really looks. Late night, phones buzzing across agencies, lawyers reading fresh orders, program heads rewriting memos, governors' councils filing the next motion, congressional offices counting defections, and the public watching the gap between power and authority widen into a canyon. The administration wanted obedience. It got injunctions. It wanted punishment. It got reinstatement. It wanted dominance. It got a docket. And a docket does not fade. It accumulates. It hardens. It becomes accountability, and accountability is where this ends.